My name is Umar Clark, founder of the Bureau Bullies. I've been in the credit space for well over 10 years now. Through multiple failures, I've learned how to beat these companies at their own game.
And then we're going to put together an action plan.
We built this platform to empower consumers to fight back against inaccurate credit reporting, abusive collections, and a system that depends on you not knowing your rights. Through education, strategy, and consumer law awareness, we've helped consumers remove millions of dollars worth of debt from their credit reports, and we've shown everyday working class people how to sue and win without an attorney. Our slogan is simple: sue them all. From the United States to communities around the world, the Bureau Bullies is here to help consumers stop being afraid, start understanding their rights, and take their power back. Welcome to another episode of the Bureau Bullies podcast, aka Sue Them All. It's a little bit different today. I got the team in the video, so they're actively working on clients while we shoot this. But today we will be talking about a very important subject that a lot of people have asked about. And after COVID, a lot of people went through it. It's been a very big topic, especially after some famous influencers have went through the whole bankruptcy process, such as Pinky Cole, etc. But bankruptcy is nothing new at all. It's not a bad thing. I just always tell people, if you're going to do it, make sure you have a solid plan or a solid reason. It can be a very good tool if you know what you're doing or if you have the right guidance when doing it. But the subject matter of this video is not whether or not you should file bankruptcy. The subject matter of this video is how to remove a bankruptcy once it's hit your report. So that's what we'll be going over. There are little bits and tricks that a lot of people don't know that we utilize to get bankruptcies removed. Most of you know that Experian, Changing, and Equifax support bankruptcies, but most of you don't know where they're getting the data from. They have companies that they utilize as vehicles, we could say, to go and get this information, because the bankruptcy court or federal courts in general do not report to CRAs, and they probably never will for a host of reasons. But for instance, Experian and Equifax gets their data from a company called LexisNexis. So the first half of the video, I'm going to be going over LexisNexis, then we're going to actually go over how to actually remove it. I have my notes here, so you see me look down at my notes every few minutes just to make sure I'm staying on task, all right? Keep in mind, I'm not an attorney. We do not give legal advice. So we're looking at how to remove a bankruptcy from your credit report. And what I want you to know is this: it does not matter what chapter you filed, whether it was discharged or not, whatever, it doesn't matter. This method will work for every single thing you're talking about. Now, the thing about a bankruptcy is it is the most expensive, in my opinion. I could damn near say it's a fact. A bankruptcy is the single most expensive line on your credit report for a host of reasons. There are still companies that will give you lines of credit if you have charge-offs. There are still companies that will give you lines of credit if you have collections. There are still companies that will give you lines of credit if you have late payments. But there are damn near no companies that will give you lines of credit if you have a bankruptcy. It normally stays on your report for up to 10 years. It always drops you a minimum of 100 points, right? And it's the only public record that can still stay on your report right now, which we'll get deeper into in a minute. So here's a few things that you should walk away from this video knowing, so I can stay on topic, y'all keep me honest, right? 1, you should know the exact laws that you're going to have to use to do what I'm about to show you. Number 2, you should know the supply chain, who really furnishes your bankruptcy and why it's the weak point. Number 3, you should know how to do a PACER pool. That's pacer.gov, or if sometimes pacer.gov is a little shoddy, you can go to a third party. It's not the government, it's more expensive. So on pacer.gov, you can pay from like 5 to 10 cents a page. On Pacer Monitor, they charge you about $5 to $10 a document, but sometimes pacer.gov doesn't work to us, so you have to use pacermonitor.com. But you're gonna know how to do a pacer pool. You're gonna know how to cross-reference everything that's on your reports versus what's actually on your bankruptcy versus what the court actually has, etc. You're gonna know the exact dispute sequence that we use, and then you're gonna have an actionable game plan by the time you leave. Most people ask, how long can a bankruptcy legally stay on my report? Different chapters have a different amount of time they can stay on your reports, but the typical time for a bankruptcy, if you do nothing about it, is 10 years. Now, the problem with that is that's 10 years of you not being able to do anything. So this is why I say, you know, if you had a charge off or something, you can still potentially make moves. Once you get a bankruptcy, you're almost SOL. So a Chapter 7 bankruptcy is going to stay for up to 10 years. It's counted from the date of filing or the order of relief. And the reason why it stays on stronger is because it has no repayment plan. And that Chapter 7 goes the full statutory term. Chapter 11 stays in your report up to 10 years. It's counted from the day of filing And the reason why is because it's a reorganization and it's treated like a Chapter 7 term. Chapter 13 typically stays on your report for 7 years. It's counted from the date of filing. The reason why it's not counted for 10 years is because it goes by the Bureau policy for repaying debt. So it stays on that same 7 years that a charge-off would, etc. Now the debts inside it stay on for 7 years. It is from the original date of first delinquency and it cannot be re-aged by the bankruptcy. Normally you'll see celebrities file Chapter 13. So believe it or not, some of your favorite celebrities have Chapter 13 bankruptcies on their report. Such a common name, your President of the United States, Donald Trump. Common name, the rapper 50 Cent, etc. These people, well, by now 50 Cent has fell off because it's been about 7 years. But this is what happens when you file bankruptcy. And if you look at the reason why you shouldn't feel ashamed of yourself, you have done, if you actually look at them, still living a pretty good life. So bankruptcy is not in your life. It just sometimes might hurt your credit report and then you have to learn how to get it off, which you're gonna learn in this video. Here's an interesting thing. After 2017, a bankruptcy is actually the last public record standing. What I mean is the bankruptcy is not the only public record. I could pull up all of your civil judgments. If anybody sued you and got a judgment, I can pull it up. If you had tax liens, I can pull it up. Just the most common and known one is bankruptcies. But now, since 2017, a settlement called the National Consumer Assistance Plan, it forced the CRAs, Experience, Transient, and Equifax, to clean up public records. They had to all attach real identifiers and verify with the courts on a schedule. And because of that, most public records couldn't survive it. The only public record that they could actually match with a schedule was a bankruptcy. So this is why you no longer see, since 2017, you no longer see judgments on your report, and you no longer see tax liens on your report, but you still see bankruptcies. Now, why is this everything? Or why does this mean so much? Judgments and liens got purged because they couldn't meet the strict identity plus the verification standards, right? Bankruptcies, whether it's Chapter 7, 11, or 13, are held to the same exact standard. They have to carry accurate identifiers and be verifiable with the source. If yours can't clear the bar on demand, it has no business on your report either. Now, here's an interesting fact about bankruptcies, right? If I dispute a charge off, that's what Amex gets an ACDV notification and they can decide whether it's verified or not. With a bankruptcy, if I dispute it, they allegedly claim they verify with the source, which is supposed to be you or the bankruptcy court, but the bankruptcy court tells you they have filed this bankruptcy with the court. So LexisNexis goes and gets your bankruptcy through a software that they own called Banco, B-A-N-K-O. And the entire role of Banco is for Banco to go searching the federal court registry, grabbing all bankruptcies that happen, and giving it to LexisNexis. Then LexisNexis sells it to Experian, TransUnion, and Equifax, and that's exactly how your bankruptcy gets reported to Experian, TransUnion, and Equifax, and that's how everybody has a record of your bankruptcy. So the question becomes, who actually puts the bankruptcy on your report? You have the bankruptcy court, which is PACER / the clerk. That is sent through the Banco, aka LexisNexis. LexisNexis sells it to the Big Three, and the Big Three puts it on your report. The crack in the wall is this. Nobody at the court is saying, hey, let me call Equifax after so-and-so, 50 Cent files bankruptcy. The bureaus buy this data from the vendor, LexisNexis, and list the court as the furnisher, which is completely false and inaccurate because the court never furnishes. The court does not have a subscriber agreement with Experian, TransUnion, or Equifax. But courts generally do not respond to verification requests. That means when you dispute, there's often no one who can truly verify it. Their only argument is it's public record, which we're going to expose in a minute. It is public record, but we're going to show you how to circumvent that in a minute. LexisNexis for Experian and Equifax is the source feeding the CRAs. TransUnion has another one. It's called LQI. Y'all can look that one up. They're actually a little bit easier to deal with, but I want to deal with the harder one now. A few facts about LexisNexis is that it's a consumer reporting agency just like Experian, TransUnion, and Equifax. It's no different. LexisNexis Risk Solutions keeps a file on you. All real estate transactions, LexisNexis have it. If your license was ever suspended, all speeding ticket, LexisNexis has it. All liens, LexisNexis has it. All judgments, LexisNexis has it. All bankruptcy records, LexisNexis has it. Now, because it's a consumer reporting agency, it owes you the same FCRA duties the Big Three does. Accuracy, reinvestigation, and deletions of what it can't verify. Now, if you attack the source first, which is LexisNexis, you can cut the head off of all two, Experian, TransUnion, and Equifax at once. So all you have to do is the first step you need to take, pacer.gov or pacermonitor.com, search your name or your case number, download your bankruptcy, read everything to the T. Don't do nothing with that. Just read it, make sure it's accurate. Make sure these are actually, the things that are included were actually included, things that they say weren't included, verify it. All right. Then you want to pull your free LexisNexis consumer disclosure report. All you have to do is go to consumer.risk.lexisnexis.com and press request a consumer disclosure report. After that, if you can't get it online, you can always send a letter by mail and get it there, or you can call in and have it done. I just prefer if you do it online because it speeds the process up. We mentioned how Experian and Equifax get their data from LexisNexis, and TransUnion gets theirs from Lundquist Consulting, but now it's known as G2BR2. Right, and since 2018, they've been the ones that feed TransUnion, and they get the data the same way Equifax does. They have their own company that pulls it, they scrape Pacer, and then they sell it to the big C, and then they sell it to TransUnion. Then you have another company called Acer, AACER. It's an independent Pacer aggregator, and it's used by creditors and law firms. And it's just a court, not mandated, but it's a court middleman. They go and pull data and they sell it. It just shows you that your data is worth a lot of money. So we spoke briefly about Banco. Banco is just LexisNexis's nationwide bankruptcy engine. It's the machine that scrapes the courts, decides if this filing is yours, and feeds it to the CRAs. All you have to know is that this is just I want you to know that this is the machine, and this is where you have to break it. Now, you can't dispute anything with Banco because Banco is not a CRA. Okay, so what is Banco specifically? BANKO. Banco is a commercial data product. It's not a courthouse. It's just a part of the LexisNexis product line that discovers and tracks bankruptcies nationwide. It markets 4 jobs. Number 1, it discovers new filings. Number 2, it monitors your case progress. Number 3, it acts fast when it's scraping. Number 4, it just makes sure that this case stays compliant. It's sold to all the people who want your money: banks, lenders, debt collectors, debt buyers, so they can chase or write off accounts the moment a filing hits. So we want to look at what Banco does and its weak spots. So its strength is discovering bankruptcies. Another strength is monitoring. And then another one is how fast they're willing to act, right? But the weak spot is matching and linking. Every job that Banco does depends on one fragile step: software deciding whether the filing is yours. There are no humans sitting there verifying. And the dates, amounts, and statuses have to be right. The thing is, they use AI and they automate it end to end. So no human ever reads your discharge orders. No one calls the clerk. A machine matches a record to a name and ships it off. So they'll put any garbage on your report. If the match or any field is off, the CRAs repeat that exact error, and that error is your opening. There's always an error when it comes to bankruptcies. So here's how to turn Banco into leverage. Number 1, you have to understand, if it's automated, it's almost always unverified. Number 2, there's almost always bad match fails. That's just their since 2017. You always want to attack the source. Now, there's a lot of talk on the internet about freezing reports. I'm not a person that pushes for that, because freezing reports does not do what you think it does. It'll freeze everything that was on there before. I mean, it doesn't freeze everything that was on before. It just freezes everything that was there the day of, so the company can still see everything before. Now, I'm going to save this part for then because it's very important. But I want you to remember just one thing. Ask yourself this one question: who is the furnisher of my bankruptcy? So the first thing you want to do is you want to dispute it with LexisNexis after you pulled your report. Remember, they have 30 days to verify, correct, or delete. And if any item of information is found to be inaccurate, can no longer be verified, the CRA shall promptly delete the item of information. That's pursuant to 15 USC 1681A5A. So you have to really have a 30-day clock, and if the item is inaccurate, they have to remove it, which they don't do. So courts have already ruled that rubber stamping is not enough, and a reinvestigation must be more than parroting information received from other sources. So a bureau that merely shifts the burden back to the consumer and the furnisher cannot fulfill obligations contemplated by the statute. The CRA must actually evaluate accuracy. This pursuant to the case law Cushman versus TransUnion. So part of why you see lawyers take these cases for free is because they know that all these companies are doing is rubber stamping these disputes. So the key to your dispute, here goes step 1, your actionable step now. The key, number 1, is don't argue whether the bankruptcy happened or not. You see people getting that, hey, it didn't happen. That's not a strong enough argument. Don't argue that. You want to make them prove that every detail is accurate and verifiable, or it has to fall off. The accurate but verifiable lane is almost always the key to handling a bankruptcy. If a bankruptcy genuinely happened, don't waste your time or credibility pretending it didn't. And instead, you want to force the system to look up every data point with the source when we know there is no source. So when that source won't or can't confirm, that's when it makes it unverifiable. Next, you have to gather your intelligence. So let's pause there and do our step-by-step from the beginning. 1, Pacer. You have to pull a bankruptcy so you can see what the courthouse has updated yourself. Does the case number match? Do the accounts in it match? Do the balances match? Etc. Then you want to get your LexisNexis report and your LQI report. Right? You get those, see if the data they have matches. Then you dispute it the same way you would have with Experian, TransUnion, and Equifax. Certified mail with a green return receipt with a copy of verified information so they can't send you a stall letter. Then after that, the thing is, there was no furniture. So here's the real trick. Once it comes back verified, you now want to send a method of verification request to all of them. You want to know who the name of the creditor was, who they spoke with, the address to that creditor, and if applicable, the phone number. We know this doesn't exist because the only furnisher would have been you or the bankruptcy court. Neither one of you furnished them. They're going to lie, and they're going to say, hey, we verified this with so-and-so or the court or whoever. That's when you then write the court and ask the court if this was true or accurate. The court will respond and let you know, and they'll actually put it on paper. The court will put their response on paper, and they'll make it clear that they do not report to bankruptcy courts at all. This is where you trap them. At that point, most attorneys will take your case for free, but if you feel comfortable, you can do it yourself. So here are the documents, after you've pulled your bankruptcy on Pacer, here are the documents that hold your ammunition. Number one, the voluntary petition form. If you file bankruptcy, you know what that is. The schedules and SOFA, S-O-F-A, the notice of 341 meeting, the discharge and dismissal order, the final decree / case closed, and the docket sheet itself. All of these things have to add up, and these are 6 to 7 data points that because it's so automated, they almost can't add those up. You want to cross-reference the autopsy of each one of those things I mentioned versus what's being reported. Then you want to line up these fields, what the court has versus what's reported. The case / chapter, the filing date, the status, the discharge date, the date reported / updated, the liability / assets, and your identifiers. If any of those data points are off, then you got you in, or you're out, I should say. So here's what a winning discrepancy looks / sounds like. Filing date mismatch, which I see a lot. Wrong disposition, reporting past its time, liability amount off, identity field wrong, or the source can't confirm it. From there, you need to build what's called a discrepancy log. You're just pointing out what does not add up and what doesn't add up, what's not matching, any violations, all of that. Put it all together. You disputing that certified mail. You don't even have to leave your house. You can do that with onlinecertifiedmail.com. It's literally that simple. After it comes back verified, as we stated, we then want to write the clerk and get them to respond saying that it was not, they never reported it now, and this is after you send the method of verification. Now you have grounds to sue, and one of the key things you can sue for, you got them under a sham investigation, but you can also get them for failure to maintain the maximum possible accuracy. This is how we've beaten LexisNexis multiple times with our clients, and this is also how you're going to beat Experian, TransUnion, and Equifax. So if you have a bankruptcy, you should not be concerned. You can get it removed. You do not have to wait the full 10 years, all right? So that's the end of this episode. I appreciate all of you for attending. We will see you on the next episode.